Late Friday night, while most people were asleep, a court order quietly dropped, and in a single move, it shattered months of secrecy. The judge did not protect reputations, he did not protect narratives. He opened the record, and now texts, emails, depositions, and financial documents are coming into the open, and once those words are public, there is no going back, because this case is no longer about what anyone says happened. It is about what the record proves, and what happens next could change everything. What started as a quiet behind-the-scenes legal maneuver has now turned into something much bigger. Something impossible to ignore, something that even the most powerful people involved can no longer control. And before we get into the explosive ruling itself, you need to understand the moment that led us here, because this did not happen overnight. This has been building piece by piece, document by document, text by text. While the public was being told one story, the court record was quietly telling another, and that is exactly why what happened late Friday night matters so much. Because when that order quietly appeared on the docket, it sent a very clear message that the court was no longer interested in protecting narratives, reputations, or carefully curated public images. Instead, the court made it clear that transparency now outweighs comfort and privacy and control. And that is a major shift in this case, one that cannot be undone. The judge acknowledged that the public has a right to follow these proceedings in real time, to understand what evidence is being relied upon, and to see the materials that directly impact the arguments that will soon be made in open court. And that single principle changes everything, because it means the sealed materials, the text, the emails, the depositions, the financial documents are no longer shielded simply because they are uncomfortable or inconvenient. And this is not about curiosity or gossip, it is about whether continued secrecy can actually be justified under the law, and according to the court, the answer is no. And that is where the dominoes begin to fall, because once that standard is set, the rest becomes almost inevitable. The motions to seal are denied, the requests to permanently hide communications are rejected, and the argument that certain individuals should be treated as untouchable third parties simply does not hold. And that includes people who believed their involvement was minimal or indirect or already resolved. The court made it clear that dismissal from a case does not automatically erase relevance. And relevance is the key word here, because relevance determines what the public gets to see and what must remain hidden. And in this ruling, relevance wins, which means the record now tells a fuller story, one that stretches back to early production decisions, creative disputes, financial entanglements, messaging strategies, and internal conversations that until now existed only behind redactions and sealed exhibits. And once those seals begin to lift, there is no way to control how those words will land, because they are no longer filtered, summarized, or framed. They are presented exactly as they were written in real time, when stakes were high, pressure was intense, and decisions were being made that would later become central to this conflict. And that is why this moment feels different, because it is no longer about allegations or responses or press statements, it is about receipts. And once receipts enter the chat, the story changes for Iveras. The order breaks down exactly what will and will not remain sealed. The pattern becomes impossible to ignore, because the materials that were most aggressively fought over are the very ones the court now says must be seen in full. And that alone tells you where the real pressure points are: the communications with representatives, the discussions about press strategy, the internal reactions to backlash, the behind-the-scenes coordination that shaped how events unfolded publicly. And the court was not persuaded by arguments that these were harmless private exchanges, or that releasing them would unfairly burden uninvolved parties, because what the record shows is active participation, direct involvement, and influence that extended well beyond passive observation. And when full sealing was requested without proposed redactions, that choice backfired, because courts do not reward all or nothing gambles, especially when transparency is at stake. And so instead of narrowing what the public would see, the result is that entire sets of communications are now coming into the open, unfiltered, and unsoftened. And this includes texts discussing premieres, reputational concerns, messaging, coordination, and responses to criticism during key windows of time when public perception was actively shifting. And the significance of timing here cannot be overstated, because the court record establishes that awareness of backlash existed earlier than previously claimed, and that acknowledgement undermines later narratives about when and why certain actions were taken. And once that inconsistency is visible, it invites questions that no amount of retroactive explanation can fully answer. And the same applies to financial disclosures, because when entities attempt to shield ownership structures, revenue flows, or decision-making authority, the court looks closely at whether those details are actually central to disputed issues. And here, the court concluded that they are, which means investment stakes, board updates, compensation structures, And financial relationships are no longer abstract background details, they are part of the story. And the court treated them that way, allowing only minimal redactions where genuinely necessary to protect uninvolved individuals, and not to preserve comfort or avoid scrutiny. And this equal application of standards matters, because it shows the court is not targeting one side while shielding another. It is applying the same test across the board, and that is why this ruling carries weight, because it signals that influence, status, and familiarity do not change the rules. Once evidence is tied to claims, defenses, or credibility, it becomes fair game, and that includes communications with studios, agencies, consultants, and public-facing intermediaries whose roles are now firmly in the spotlight. And as these materials are refiled, the picture that emerges is not fragmented, it is cumulative. Each text adds context, each email adds motive, each document fills in a gap. And by the time the oral arguments begin, the public will not be walking in blind. They will be following along with the same materials the court is using to evaluate what actually happened, and that level of access is rare and intentional. And it sets the stage for a reckoning that is no longer theoretical. What makes this moment especially striking is how much of what is being unsealed contradicts the idea that events spiraled unexpectedly, because the documents show planning, anticipation, and awareness long before public narrative shifted. And that matters because intent is shaped by knowledge, and knowledge is reflected in contemporaneous communications, not hindsight explanations. And the record includes discussions about creative control, casting decisions, messaging, coordination, and reputational management, all happening alongside acknowledgments of audience reaction and internal concern. And when those threads are viewed together, they form a timeline that is difficult to dismiss as coincidence, and the court clearly recognized this, which is why it emphasized the importance of allowing the public to follow along with dispositive motions. Because summary judgment is not about hypotheticals. It is about whether the evidence supports the claims as a matter of law, and sealing large portions of that evidence would undermine the very purpose of the process. And so the court chose openness even where it creates discomfort. And that discomfort is now unavoidable, because the communications do not exist in isolation, they interact with each other, revealing patterns, escalation, and response cycles that speak louder than any single message. And the same applies to depositions, because testimony given under oath carries weight, especially when it aligns with documentary evidence. And here, multiple depositions are now unsealed, allowing viewers to compare what was said privately with what was stated formally, and consistency or lack thereof will not go unnoticed. And that is why the ripple effect of this ruling extends beyond this case, because it sends a message about how courts view attempts to overseal materials under the guise of privacy when the real concern is exposure. And the court made it clear that privacy must be real and specific, not generalized or speculative. And that standard narrows the path for future sealing requests significantly. And as these materials become public, they will inevitably be examined, analyzed, and contextualized. But the court is not responsible for how the public reacts, it is responsible for ensuring fairness, access, and integrity of the judicial process, and that is exactly what it prioritized here. And the result is that control over the narrative shifts away from carefully managed statements and back to the record itself. And once the record speaks, it does not whisper, it accumulates, it echoes, and it leaves very little room for selective memory. And that is why this ruling feels like a turning point. Not because it declares a winner, but because it changes the terrain entirely, with oral arguments now open to the public and materials refiled under far fewer redactions. The next phase of this case will unfold in full view. And that visibility alone alters behavior, strategy, and expectations, because when decisions are made knowing they will be scrutinized in real time, the margin for spin narrows. And the court acknowledged that the public interest here is not abstract, it is concrete. Because these proceedings involve widely discussed events, major commercial interests, and questions about conduct, accountability, and responsibility. And the law does not operate in a vacuum, it operates in society, and society is watching. And what happens next will not hinge on speculation, it will hinge on what the documents show, what the testimony supports, and how the arguments connect those dots. And the court has already made clear that it will not artificially shield parties from the consequences of their own words simply because those words are uncomfortable. And that principle now governs the remainder of this process. And as the refiled materials hit the docket, they will provide context for arguments that once felt opaque, and they will allow observers to understand not just what is being argued, but why. And that level of clarity is rare and powerful, and it also raises the stakes. Because once evidence is public, it cannot be unseen, and interpretations cannot be easily walked back. And that is why this moment carries such weight, because it marks the end of ambiguity and the beginning of accountability driven by the record itself. And no matter how the court ultimately rules on the underlying motions, the impact of this unsealing order will linger because it reshapes how the story is understood, and how responsibility is assessed, and how future disputes may be litigated. When powerful interests collide with public transparency, and as the arguments approach, one thing is certain: this case is no longer happening in the shadows, and the words that were once hidden are now part of the permanent record. This ruling changes everything, not because it decides the case, but because it removes the curtain, and once the curtain is gone, the story must stand on its own, supported by documents, testimony, and timing, not by framing or damage control. The court made a deliberate choice to prioritize public access over private comfort, and that choice has consequences for everyone involved, because credibility is built in consistency, and the record now allows that consistency to be examined in full as the next phase unfolds. Viewers will not be guessing, they will be reading, watching, and following along with the same materials that shape the legal argument, and that transparency is exactly what the court intended. Whether it benefits or burdens any particular party is beside the point. The process itself demands it, and that is why this moment feels like a reckoning, because it forces alignment between what was said privately and what is claimed publicly, and when those align, trust follows, and when they do not, questions multiply. And the answers are no longer optional, they are required. And as this case moves forward, one thing is clear: the narrative no longer belongs to any single voice, it belongs to the record, and the record is finally speaking. This moment marks the point where the story stops being controlled and starts being examined. And that distinction matters more than anything else, because for months, the public conversation has been driven by selective disclosures, carefully worded statements, and strategic silence. But what the court has now made clear is that narratives do not outweigh records, and influence does not outweigh transparency. And that is a shift that cannot be undone once the documents speak for themselves. They do not care who benefits or who is uncomfortable, they simply exist, and the court has made it clear that existence alone is enough to justify public access. When those materials form the foundation of legal arguments that will decide real outcomes, and that principle now governs everything that comes next. What makes this reckoning so significant is not just what is being unsealed, but when and why it is being unsealed. Because timing reveals intent, and context reveals motive, and together they form a picture that no single quote or message could ever fully capture. This is not about isolated texts or one email taken out of context. It is about patterns that emerge across months and even years of communications, decisions, reactions, and internal acknowledgement. And when those are placed side by side, the story becomes harder to dismiss as misunderstanding or coincidence. The court recognized that and refused to allow continued secrecy to distort how those patterns are understood. Idea that certain people should be shielded simply because of status, familiarity, or perceived distance from the core dispute was tested and rejected. And that rejection sends a broader message about how accountability works in high-profile cases. Relevance does not disappear because a party is dismissed, nor does involvement vanish because it is inconvenient. Once communications influence outcomes, they become part of the legal landscape, and the public has a right to see how that influence was exercised, and that standard now applies evenly across the board, without carve-outs, without special treatment, and without exceptions made for comfort or reputation. As the next hearings approach, the focus will no longer be on speculation about what might be hidden, because much of what mattered most has now been ordered into the open. And that changes how every argument will be received. Credibility will no longer rest on assertions alone. It will rest on alignment between claims and contemporaneous evidence, and that alignment is something the record will either support or challenge on its own terms, and that is exactly how the process is meant to work, even when the results are uncomfortable. There is also a larger takeaway here that extends beyond this case, because this ruling reinforces the idea that courts are not tools for narrative management, they are forums for evaluation. And when evidence is used to ask a court for relief, that evidence becomes part of a public process by design, and attempts to overseal or broadly shield materials without narrowly tailored justification are increasingly viewed with skepticism, especially when public interest is high, and the issues reach beyond private disputes into questions of conduct, responsibility, and impact. What happens next will unfold in full view. And that visibility alone brings clarity, because when arguments are made openly and supported by accessible records, the public does not have to guess motivations or fill in gaps. The information is there, and interpretations can be formed based on substance rather than suggestion. And that clarity is ultimately what this ruling protects: not one side, not one narrative, But the integrity of the process itself as this chapter closes and the next begins, one thing is undeniable. The balance of power has shifted from controlled messaging to documented reality. And no matter how the final rulings land, that shift will shape how this case is remembered and understood long after the hearings conclude, because transparency once granted cannot be taken back, and the record once unsealed cannot be rewritten, and that is why this moment matters, not just for those involved but for anyone watching how accountability unfolds. When the spotlight finally turns on, if you followed this story from the beginning, you already know this was never just about one dispute, it was about who gets to shape the truth. And now that answer is clear, the record does, and the record is finally being heard.